Hello and welcome to our podcast at Get Legally Speaking. Our legal conversation today will be divorce law. I'm here today with Miss Maria Scotland from 5 St Andrews Hill Chambers in London. Maria is joint head of the family team at her chambers and she is also a leading family law barrister. Thank you for joining us, Maria.
Hello, and thank you for inviting me.
Yes, wonderful. Okay, so let's crack on. So let's talk about some of the most commonly asked questions in divorce. So one of these questions are, what do I have to do to get the divorce process started and how does this work?
Right. Well, the first thing I'd say, and it may seem obvious, but I think it's worth saying, is has your marriage ended? Has your relationship ended? Because a lot of people say, well, how do I get divorced after an argument? They feel that their marriage is broken down, but they haven't attempted to save their marriage. Now, I'd say that because I think that you should make sure that your marriage has ended, attempt mediation, relate, start your process conciliatory if you can. So if you can talk to the other side, make sure that they also agree your marriage is ended, it makes the process easier. Because a lot of what us lawyers see is fighting between people in the courts because there's feelings that are unresolved. Anger, hatred, bitterness. Yeah. He left me, he had an affair. So the divorce process, it's always better if you can start it if you can on the basis that you...
Some sort of mutual agreement,
exactly,
yes,
and it's conciliatory.
Yeah.
Now that isn't always, that's great, blue sky, that's great. But I would say that because the whole process is designed that you first attempt mediation. The courts mandate that you should attempt mediation first.
Yes,
so
we're going to sort of give a brief about what is mediation, what's involved, where do you go with it, where do you start?
But mediation in the easiest and most explicable plain English terms means talk to the other side, talk to your partner, your husband, your wife, if you can. Yeah,
you try to have that
family member. Sister, brother, and if not, then a professional.
Yeah.
But to then, you have decided your marriage has ended, you can't speak to the other side, or they've mutually agreed that your marriage has ended. The divorce process, what you need to do in England and Wales is you need to petition for divorce. What that means is you make an application in the family court. Everybody's heard about the criminal courts. Everybody knows about civil courts, county court. There is a separate family court. And everything can be done online, like most things nowadays. You can apply for your divorce online. It's really simple.
Can you now do it completely online?
You can do it online.
I actually didn't know you could do it completely online.
Yeah, you can do it online. And I would advise anybody to start at the online process. If you want to use a solicitor, fine, but at least start by looking at the online process because it saves you so much money.
Yes.
And it is really simple. So the online process is gov.uk. Really simple, Google it. If you Google divorce, you will get a whole load of solicitors who will tell you how they will assist you and at what cost.
Yes.
But if you go to gov.uk, you can apply online, you can do it online.
At least with some really basic information about because the first application, the first petition is actually to deal with the marriage, the dissolution of the marriage, isn't it?
Yeah.
And then there's the other side of divorce, which is the financial aspect.
Yeah, exactly. And that's a good point. Most people, when they say I want to get divorced, what they're really talking about is the paperwork which ends your marriage, which is the application or what we call the petition as lawyers. But also they're talking about how do we divide our finances. And a lot of people don't appreciate and realise that you need to make a separate application to divide your finances and file that with the court as well. And then thirdly, a lot of people need to sort out their child arrangements, and that's a separate process as well. So ending your marriage actually involves the divorce, the sorting out the finances, and if you have children and those children are young, then sorting out your child arrangements. But in order to make sure that you are divorced, the petition comes first, and then you really ought to think about the finances.
Yes, and obviously it's very important once you've issued the petition or made the petition for divorce, so to speak, whether you do it through a lawyer's or whether you do it yourself, to make sure that you don't get what's called the decree absolute, which is the last stamp of seal saying this marriage is now dissolved before your finances have been agreed and settled. That's a very important
I think what a lot of people don't know and don't appreciate is that there are 2 stages to divorce, and you're entirely right. The first stage is what's called decree nisi. If one way of thinking is we're nearly there. That's the nearly there stage.
Yes.
And then the second stage is called the decree absolute, which is the we are absolutely divorced stage.
Yes, yes.
So there are two stages, and a lot of people don't know that, and I think that's perpetuated in the media, because you'll read in the media, so-and-so, Mel B got divorced today. No, what actually happened was she got her first stage of divorce, and the only reason that we know that...
decree absolute, by the way.
I
don't
don't
even
know.
I don't know.
And this is the thing, we won't know, because the first stage is a bit like when you got married and you publish your banns. The first stage of your divorce gets published. By that, what I mean is that if you make an application to the court to end your marriage, the courts will, on a day, put a list of the marriages that there's been an application to end those marriages, and they'll put a list up in the court building, and they will shout out, is anybody here for decree nisi? And it's a little bit like publishing your wedding band. So, and then you end your marriage, you publish it to the world. But when you finally get the stage of your divorce, that's private. So it doesn't get published.
Wow.
So when you read in the media somebody's got divorced, no, it's the nearly there stage. The we are absolutely divorced stage is the second stage. Now, historically, the reason for the two stages was to leave a gap, a moon cycle, to make sure that the wife wasn't pregnant.
Is that what it is?
Yeah.
I always thought, to be honest with you, that it was to give the parties the chance to think, is this absolutely what I want to do? It's a 6-week period,
It's a
isn't
6 week and 1 day.
between the nisi and the absolute.
That's right.
So when between the time the court announces your divorce on the nisi to when they actually issue you the absolute, so you're absolutely divorced. So it's to make sure the wife wasn't...
Yeah.
How interesting.
So it allows a moon cycle, 6 days,
Wow.
6 weeks and 1 day. That's the earliest time that you can apply for the absolute. So when you... The process is that you apply for your divorce. You can apply, like I said, online. It's called a petition.
That's the first
then
bit.
and then when the court receives that, it will send out your petition to the other side. So if you're the wife, it will send it to the husband at the address you gave for them. If you're the husband, it will send it to the wife. That party then has to return a form saying, I acknowledge I've received it.
Yes.
And then they can either contest the divorce or they can consent to the divorce.
And the document's headed up acknowledgement of service,
It's acknowledgement of service.
Yes.
And then once that is received back, you then apply for the first stage, the nearly there stage. And that's when it gets published around the courts. Then you have to apply for the end of your marriage, the decree absolute. The earliest time you can apply is 6 weeks and 1 day after your decree nisi. So it allows for a moon cycle.
Yes,
I mean,
yes.
that was historically.
I have had one case. In 8 years, I've had one case which turned around and said, we've made up. And it's lovely. I mean, it's really rare, but it was really lovely.
Yeah, I have seen cases where people have refreshed their petitions and they've allowed their decree nisi to get old because they've got back together, or they've just had second thoughts, and then got back together and thought, actually, do you know what, this marriage has ended, let me go forward with my divorce petition. So yeah, there's two stages, and like you absolutely rightly said, those two stages are used by lawyers and should be used by people to sort out their finances. Reason being that if one of you died and you were divorced, then you would no longer have any marital rights. So
if you've had the absolute,
and that affects, in particular, your pensions. So if somebody dies, they die without a spouse. There's no spousal rights. So that's really
and
where
inheritance as well.
Yeah,
doesn't
absolutely.
it? I mean, because it's also there's another side to that as well, isn't there? Where if you're actually divorced and the other side, you haven't sorted out the finances, and the other side goes and wins a lottery, sells a property, buys a car, so buys an asset or sells an asset, or you can't be entitled to any of that, can you? Once the divorce has been finalised,
what you'd have to do, you'd have a wrangle then with under the Inheritance Act with their estate, and that's a whole messy business that you don't really want to get involved in.
But don't want to leave. If they haven't died and they've accumulated more assets, and you still haven't had your financial,
then you're the wife.
Yeah.
And then you are entitled, well...
No, if you're divorced, but you haven't sorted out the finances.
It leaves you in a world of mess.
Yes.
A whole world of mess. It's a whole other podcast on inheritance and estate.
So
and you read about that, don't you?
Yeah,
you read about the wrangles between the brothers, the sisters of the dead. In fact, there was one recently, wasn't there? There was husband and wife both died, bless them, they were both really old and they died together, and the argument was who died first. But anyway, so yes, you're left in a whole world of problems. So sort out your finances in those in the gap between.
Before you apply for your absolute. And if you're the party that hasn't petitioned, so you're the husband petitioned in this case, and he says, or his solicitor say, we are going to apply for the absolute, you've got to say, no, I'm not going to agree to that unless the finances, because if you're the party that's being petitioned against, so, you know, you need to make sure you let the husband or the wife, solicitor, whoever it is, know that you're not ready for the absolute if the finances have not been sorted.
Finalised. Absolutely, I agree with you. Most good solicitors, though, wouldn't apply.
I've seen it. I've seen it, Maria, and I tell you, it's
there are
shocking.
There are ways of protecting yourself, but you don't want to have to take that step. A simple, like you said, an email to the other side. Please don't apply for decree absolute until we've sorted out finance. That will hold the fort.
Yes, no, absolutely. I mean, that's really, really interesting. And another question that people often ask is, do both parties have to consent for there to be a divorce? So say the wife says, I'm not going to divorce you, tough, you're not going to give it, you're not running off into sunset with your mistress or without me or whatever.
Well, a lot of people will have read and have heard about the arguments over no fault divorce. In this country, you cannot have a divorce where there's no fault unless...
That's a massive question, because lots of people say, but she cheated, or I think he's cheating. Let's explain that little no fault basis, because I don't think enough people understand that, to be honest with you.
To end your marriage, you have to cite a reason. You have to tell the court the reason that you want your marriage to end. The easiest reason, where there really is no blame on either side, is we've been separated for more than 5 years. If you've been separated, if you have, and you know what, I don't think many people are nowadays. No. My more elder clients who their children are grown up, or they've never had children and they're into their later twilight years, they tend to separate and only for whatever reason one person's met somebody else after a long period want to get divorced. But most people, by and large, most of my clients don't separate for 5 years.
My husband for 2 years during my divorce years ago. We lived in the same house. You know, we just didn't live. That's those separate lives. It's a case that you know most people do, like you say, they still do live together. So most people don't. So if you've been separated for 5 years or more, you can get divorced without the other person's consent. And so that's probably the most straightforward. But other than that, the basis of which you can get divorced, or the reasons that you can ask the court for a divorce, include adultery, and the other person has to agree that they were an adulterer, which could be quite
on their acknowledgements, or it can be, and it's like throwing a grenade. Even if the other person is having an adulterous relationship, what tends to happen is you then start off on the back foot, and there's acrimony. So there's adultery,
irreconcilable differences, which I love that heading, because it covers a lot again without pinpointing.
That's your behaviour. So that's your unreasonable behaviour. You can have 2 years separation, but you still need the other person's consent. But by far and large, we tend to see people who need to get divorced. They've not been separated 5 years, not been separated 2 years, or the other person won't consent. They need to cite unreasonable behaviour and
make an application. You need the court to say, yes, I will allow you to go ahead, even though the other side doesn't agree. So.
What happens? You know, we talked about the process. So if let's say you go online, you file your petition, you have to tell the court what ground. So why are you getting divorced? If it's not 5 years separation, it's not 2 years and the other person consents, it's unreasonable behaviour, adultery. The other grounds include haven't consummated my marriage. Well, I think in 25 years I've seen that once. So most people come under the unreasonable behaviour.
Not consummating your marriage.
You didn't have sex.
Yes.
You didn't have sex. Sexual relations after you got married.
But it means at all, doesn't it? Because I had a client once call me and say, look, you know, we only had sex twice in the first year, and was it.
That's consummated.
So we didn't go. So consummating your marriage, just to be absolutely clear, is you've had sex at least once after the day after you were married,
and the other person does have to. So you cite your grounds, and as you said, there's you have to tell the court why. That gets served on the other side, and the other side then have to say, do they agree that your marriage is ended, and do they agree with the grounds?
Yes.
And that's where the only time that they don't get asked if they agree, and they don't ask whether they agree your grounds, is when it's 5 years separation. Otherwise, they do have to agree. They have to take consent, and if they don't, then the court lists it for trial. So that
and gets both parties in front of them, potentially with legal representation. And you're talking about the real beginning of the process. So to spend money or time or get stressed at that stage, it's a lot to bear, isn't it?
That's where I'd say, you know, if you've had an argument, you feel, I can't live with this any longer, my marriage has come to an end, try and start conciliatory, because the acrimony, the emotional stress dealing with the other party through paperwork, through the courts, the costs, if you don't instruct a lawyer, you do it yourself, it's still a cost to you emotionally. It's so much stress.
Oh God,
if you can
start
off
very, very, very draining. But
on
if you can start
some sort of...
I mean, what I've seen is if there are lawyers instructed from day one, the good thing is that if you've got good lawyers, and what I mean by good lawyers here, I mean lawyers that are prepared to work together to make life easier for their clients. So, you know, I've often picked up the phone or I've said, look, let's just agree these grounds for divorce. Let's not make this an issue. So let's give and take. Okay, you know, we're not going to sit there and pinpoint and be nasty about it.
Good lawyers will fight their client's corner, but still turn around and say to their client, look, there's no point you fighting this. What we can do is we can say we don't agree the grounds and we say she was this and that she was that. But we agree there's a divorce. And let's just write it to the court, say we don't agree, these are our grounds as well, but let's get divorced. So the answer, long-winded answer to your question is, do they have to agree?
The law is long-winded though, really. That's the point, isn't it? Because there's so many, like we have just covered 2 questions, but there's so many strands that we could have gone on within those questions, isn't there? And then another big one, and I certainly asked this years ago, and I was astonished by the answer, and I was even more astonished when I came out the other end, is how much does a divorce cost? People say. I remember I went in and I said, well, how much is it going to cost? And I was quoted, between £5,000 and £7,000. And at the time I thought, what? £5,000 and £7,000? I mean, I'm going back 15 odd years now. It cost me £40,000 when I came out the other side, and
that's not unusual.
And that's not an unusual figure at all. And you're talking about I had no children at the time, so there was a few properties that we owned, not many. What's the answer? What's the average answer to that question?
There is no hard and fast rule about how much it costs. I can tell you that a divorce process which involves sorting out the divorce and the finances, you'd be lucky if you sort it in 6 months. So it usually takes anything between 6 months and much. It depends on the complexity of the case. But the court process is also slow, and negotiating can be incredibly slow, and it takes people time to process things. 6 months to a year is on average the round about the time scale. So then if you are using a solicitor, and a solicitor will charge you hourly rates every time that you pick up the phone to them, every time they write to you, every time they see you in conference, plus they will charge you then for court appearances, barristers, etc. A year of that, 40,000 is about average. But I mean, what's average? Look, in London, the normal property, normal 2-3 bedroom property costs £1 million. So 40,000 nothing. Maybe up north.
Is the average now, isn't it? Or something. I read that 600,000 was the average. But I mean, the average time we're seeing divorce processes take is 2 years. Right. Because parties are slow to respond. There's such an emotionally charged process, isn't it? That people, some people bury their heads in the sand and they just don't want to be answering the questions that they have to answer to help getting the case moving. Like you said, the court timetables, I mean, that is not set by lawyers. No. That's set by the court.
And they're slow. Our courts are full now.
Well, the average time for a date is 4 to 6 months for anything. And so the more you argue, the more your lawyers are not able to resolve, the more applications need to be made to court, the more time has to pass waiting for those dates, and the more money you will spend. So yes, I think you're absolutely right. That £40,000 is an average per 12 months of time that it could go on for. And the average divorce that we've seen certainly over the last years are, I would say, 2 years. Big question. And then again, I think we sort of looked at how long would the divorce process take. Depends how many complex
It depends. A really straightforward case would take 6 months.
And that's, I think, if you agree on everything.
That's agree on everything, and that's where
you're
you're
the dog,
prepared.
The cat,
yeah,
the lot.
And that's where you're prepared to negotiate, discuss, and agree things, and then put it into an application. It's all by consent. If not, the process takes much longer.
Yes.
And like you said, it can take. Well, my experience.
It can go on for years. It can go on for years. I mean, mine took 3. I think in the end it was just over 2 years with no arguments.
Yeah.
And I didn't, at the time I didn't own a law firm and I didn't know what was going on.
Yeah.
But it could take years.
Yeah. When I see the case, usually it's been through solicitors, and so there's been some longer period of seeing a solicitor, the divorce petition being issued. From my experience, from the time I see the client until the end of the process, between 6-12 months. But of course, there's been the period before, so you're probably right. Although nowadays there are more options available for people. They don't have to use solicitors; they can do it themselves.
Yes.
They can also come to barristers direct. I do a lot of direct access work.
This is a big subject, and this is something that I think people really need to be aware of. In that, if you go to a law firm that does bring you to a barrister very, very early on, my law firm certainly does, or if you come direct access,
and that's unusual. That's very good.
Yes, it is unusual. It is. They come direct access very, very early on.
Yeah.
What you get is robust advice and guidance and strategy from the beginning.
Yeah. Yeah. Rather than let's send this off and wait for the reply.
Write letter. Yeah.
Yeah.
No,
this is what we're likely to get at the outcome. This is the end of the road.
Yes.
Let's take the quickest route
and
to that.
Because we know where we're going. And I think one of the most important aspects of that advice, if I may say, Maria, is that you should take advice on a financial settlement from day one.
I agree.
Because a lot of the arguments that we see are because people cannot agree who's going to have the house, who's going to get the equity from the house, how much of that equity, who's getting the car, and then it goes down the food chain. And that's even before, if there are children and there's issues around the children, even before you've even got to that stage of things.
Yeah.
So I think it's very key that a barrister sits down with the client and says, right, this is where I think financially you will be placed in your divorce.
Absolutely.
So and I'm a big fan of saying let's get an out of court without prejudice, meaning it can't be used in the courts, letter based on a sensible financial settlement now, from day one, because then we can try and nip this in the bud. Yeah,
I agree with you totally.
So,
and what tends to take time is that if you've got one party who is angry, bitter,
which is very
whatever,
common.
They won't accept it.
And understandable.
And that's where we have to be conciliatory, we have to try and be amicable, but at the same time robust.
Yes.
And it's a form of mediation, because at the end of the day, you've got two people who coexisted together, and it's trying to unpick their emotions. Really, it's not about the finances. This is not rocket science. What gets involved and makes things difficult is the emotions. You aren't doing this to me. You're not having.
You're not having that. You're not going to stay in a 4-bedroom house while I have to go and rent.
Exactly.
I've heard it so many times, and it's reality though, isn't it? I mean, and what we tend to do, is we tend to say, right, let's try and give the client that confidence that we're going to take the heat. And I think as much as we do that as a shop front, and then the barrister can really sit there, you can sit there and think, right, give me the facts, let's lay it out, and try and get a strategy and a common sense approach, because we are not, as lawyers, we're not, or the legal team, we're not emotionally attached to what's
the good
going on.
The good barrister and the good solicitors are the ones that help their clients unpack the emotions and see the facts and look at the figures unemotionally, but can empathise that this is all about emotion, but can recognise that, help their client work through it. There's a little bit of therapy, I suppose, if you could say, but there's a humanity.
As a law firm, we have a lot of therapy going on. From both ends, it's quite interesting, because a lot of it, like you say, it's not rocket science.
No, it isn't really. It becomes it, because you can't focus.
No.
Your clients can't focus on. They don't hear what you're saying because they're caught in their emotions.
And also, it's very difficult, I think, for to understand what's going on if you've never been through it before. And even we've done divorces where we've done second time, and even the second time, clients struggle with it because they're so busy dealing with the everyday of the life.
Yeah.
You know, if you've got children, that becomes even more complex and difficult to deal with. And then trying to understand the legalities and the legal terms and what she's saying and what he's saying and what he wants. And then you've got the family and the friends in your ear saying, "Oh no, I wouldn't do that," you know. And
Yeah.
But look, it's been really lovely speaking to you, Maria. Thank you ever so much for your time.
No, it's my pleasure entirely. It's gone so quickly.
It has. It's been 25
Don't ask
minutes.
a barrister to talk for 25 minutes. We'll talk for an hour. We've hardly got through anything. I do apologise.
I have to say, you know, obviously we're going to be doing this again very, very soon because this topic is huge. I think we probably cover one question with all the strands per episode, really. But look, don't forget to click and subscribe to our podcasts. You can find us on Twitter, Facebook and LinkedIn by searching Get Legally Speaking, and also visit our website at getlegallyspeaking.com. Thank you very much for listening.